Welcome, colleagues. My name is Ian Kissel. I'm a professor at Cornell Law School and a member of the steering committee of the Global Strategic Litigation Council. I have the honor today of co-hosting this event with the Refugee Solidarity Network, and it's my pleasure to welcome you all to our event, Decolonizing Refugee Law. We will be spending the next 90 minutes discussing this important topic, and I'll just give us a couple of points of orientation. First, I want to note that the webinar is being recorded. I also want to emphasize that we hope that the dialogue at the conclusion or in the last portion of our webinar today will be active. So please feel free throughout the remarks to enter questions in the Q&A portion of the toolbar at the bottom of your Zoom window, or in the chat also at the bottom of your toolbar. The Global Strategic Litigation Council for Refugee Rights is now in its second year and seeks to support litigation and affirmative development of the rights of refugees around the world. We are also excited to host things like technical assistance, individual case support, and discussions on important topics such as today. In a moment, I'll be putting a sign-up form, should you be interested in joining the council, in the chat, as well as a form to request case support if litigation support in a matter that you're pursuing related to any issue of refugee law, including decolonization related issues that we'll be talking about today, is something that would be of interest. We filed several amicus briefs in recent months. Today, we are joined by an incredible lineup of speakers. We have an opportunity to hear first from E. Tendai Achiumi, the Alice Mignana Professor of Law at UCLA Law and the former UN Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. We'll also be hearing today from Roshni Shankar, the Executive Director of the Migration and Asylum Project, who in that capacity sits also on the steering committee of the Global Strategic Litigation Council. We'll hear from Umar Gilani, an advocate and partner at the Law and Policy Chambers, and joining us also is my co-facilitator, Zaid Haidari, the Executive Director of the Refugee Solidarity Network. As I mentioned, we are just absolutely delighted to be partnering with Zaid and RSN in today's event. The legal protection of the rights of refugees and other migrants is, of course, inscribed within imperial and colonial legacies. When we think about the topic of decolonizing refugee law, some of us might think first about the colonial nature of the Refugee Convention and its protocol themselves, the way in which international law carries forward or was sort of always already a colonial structure. We might think about the process of decolonizing refugee studies. There's been a great movement in the academic field to recognize the way in which colonial legacies and existing colonial and imperial structures are inscribed within the production of knowledge about refugees, refugee protection, and the field. And of course, we might think about the way in which all of these phenomena are inscribed within domestic legal frameworks that are both the effect of colonial inequalities and carrying forward imperial legacies themselves. As I thought about this event today, I was rereading the inaugural Harold Bond lecture given by B.S. Chimney at Oxford almost 25 years ago, in which Professor Chimney reflected on the sort of the phenomenon of humanitarianism and the way in which this new, what he referred to as a new phase of imperialism, accompanied by the invention of new norms that will, in hindsight, legitimate in the name of human rights the necessary acts of violence, and in particular reflected on the way in which refugee protection and the ideology of humanitarianism would be used to emphasize security within refugee discourse, to blur legal categories and institutional roles, to turn repatriation into the only solution, and promote a neoliberal agenda in post-conflict societies that would lead to the systemic erosion of the principle of protection and the rights of refugees. It is striking and sad, I think, that prognostication now 25 years ago was a very apt description of recent decades. And I wanted to invite us to reflect on this broader framing of imperialism as well. Thank you to everyone who is joining today. I hope that you'll engage in the Q&A, and I hope most of all that we can maybe take forward the conclusion of those remarks by Professor Chimney, which is the urgency of doing justice. We hope that this discussion leads to practical engagement to advance the rights of refugees, and that is deeply connected to these broader reflections that we'll hear about. Without any further ado, it's my pleasure to turn it over now to Professor Achiume, and then following her presentation, Zaid and RSN will facilitate the next phase of the discussion. Thank you all.
Thank you so much, Ian, for that wonderful introduction, actually, and for those framing remarks, which help situate what I'm going to be discussing. And Ian and Zaid, thank you so much for convening us in the first place. So my contribution is to just offer some framing remarks, and the spoiler alert I have is that I'm coming to you with more questions than I have answers. And I see the webinar that we're having as being less about, delivering conclusions and more about deepening debates and conversations that I think are really urgent and that for sure we do not yet have complete answers to. So when we ask, what does it mean to decolonize refugee law? What can it mean to decolonize refugee law? Those questions to me at the start of this webinar remain real questions. And I don't want to pretend to be performative about questions that one already has answers to. So really starting from this place of saying this is an inquiry. And I think it's an inquiry that can be especially productive because it's not just academics talking amongst themselves, it's having a conversation with people who are doing the real work of defending people who are fleeing really terrible circumstances. So I'm excited to be a part of this event, primarily because of the opportunity to learn from colleagues who are litigating on behalf of refugees in South and Southeast Asia as well. And regardless of the framing we use to think about the work we're going to be discussing, I think it is important to mark that work as important and as worthy of recognition in its own right. And so I see our conversation as being both about learning about that important work, but also exploring another possibility, the possibility that that work and the session can be an important occasion to really situate the work that's being done by colleagues in a broader debates, I should say, transnationally and internationally on what it means genuinely to remake law and legal institutions to undo the colonial legacies that are embedded in their foundation. And so I think we are all asking how to think about this work in relation to the broader propagation of decolonizing refugee law. And so starting from that point, I think it's important to situate the question of decolonizing refugee law within a broader framework, which is really thinking about the relationship between colonialism and borders in the first place. I think that's an urgent starting point. And when we think about the influence of colonialism on borders, especially for post-colonial states, that influence is integral. Right? So the very physical spaces that are bounded by borders, when I think about the parts of the world that I'm from, which is Southern Africa, Zimbabwe, South Africa, and I'm thinking about the Zimbabwe-South Africa border in particular here because of some work that I've been doing. The very physical container we describe as Zimbabwe or South Africa is a product of the colonial project in the region. And so we're talking about a project that has shaped the very nature of borders, territorially and physically, and also the political bounds of the nation state, what it means to be unauthorized as a migrant, what it means to even be a migrant. All of these terms that are central to how we think and talk about have very clear genealogies in European colonialism and the role that law and the control of territory and movement played in ordering regions, places, practices in very real ways, right? So to talk about the coloniality of borders is not to describe something, metaphorical. It's to describe relationships and dynamics that are embedded in very fundamental institutions, even before we get to talking about what a refugee is and who a refugee is. So the point I'm making here is that we're focusing on refugee law, but it bears pointing out that colonial legacies and colonial arrangements of power and colonial ordering of people and territory is embedded in the very DNA of the post-colonial nation state, and it's embedded in international law as well. It's also embedded in other spaces that we might talk about as well. And on international law in particular, if you think about something as basic as domestic jurisdiction, which is a doctrine that does a lot of work to make immigration actually be something that states have largely reserved to their own governance. Domestic jurisdiction appears in the early 20th century as a result of US negotiations and a kind of US and other settler colonial project to ensure that immigration is something that is reserved to the regulation. So just really highlighting that international law is implicated here, even if the regimes that we're going to be looking at are more nationally oriented. The Undoing Precarity report, which I know that colleagues are going to be talking about in a moment, highlights the ongoing influences, for example, of the Foreigners Act of 1946 in Bangladesh, which is an outgrowth of a colonial era law common to Bangladesh, India, and Pakistan. And so when we are having conversations about the coloniality of international refugee law, and we're talking about decolonizing international refugee law, there can be a way of having that framing situate the problem only in international frameworks, when in actual fact, there are domestic law frameworks that are operating in the shadow of, or, you know, reproducing colonial dynamics, because those domestic legal frameworks themselves have been implicated in ways that can disappear if we only focus on international conversations as well. So one meaning of decolonization that I want to put on the table is that it involves, among other things, the slow and difficult work of remaking the post-colonial nation state and its law to disrupt the ongoing work that the nation state and also that this law does to preserve or reproduce hierarchies and arrangements that are unequal and exploitative of some for the benefit of others as well. I know that in international conversations, especially among critical scholars who are thinking about colonialism and its relationship to law, we can often think of colonial arrangements and colonial law and neo-colonial law as only benefiting former colonial powers. But in fact, colonial law and neo-colonial law in the third world, formerly colonized territories, actually entrenches domination of national elites whose race, ethnicity, religion, caste, and other categories remain the basis for preserving privileges that in many cases were hardened under colonial rule, but are not necessarily exhausted by the colonial project. And so when we're thinking about coloniality, when we're thinking about neo-coloniality, and when we're thinking about the hierarchies and injustices it perpetrates, I think the conversation we're about to have really helps us sharpen the fact that it's not only about North-South dynamics, it's also about dynamics internal to the South that are shaped again by regimes that come out of a project of kind of North-South domination as well. And just in terms of scholars who have really talked about how, you know, legal institutions in the present and in post-colonial states, you know, operate in the service of national elites in ways that are tied to a colonial project, but are not exhaustive of it. I was thinking of Mahmoud Mamdani's book, Citizen and Subject, as a really interesting intervention into that conversation. And so I'm excited to think about some of the questions that I've thought about in the context of the African continent, in the context of South Asia and Southeast Asia as well. And so when we're thinking about South Asia and Southeast Asia, and we're thinking about colonial and neo-colonial influences, I think it's important to highlight that they are not the sole basis of hierarchy and even unjust social stratification. And if we're thinking about a place like India, for example, and if we're thinking about the Hindu nationalist project that is shaping the way that borders and refugee protection are operating, it's important to think about the European colonial project as layered and very intertwined with other religious and other imperial projects that are operating at the same time, and that have to, I think, bring nuance to how we're thinking about the project of decolonization as well. So I'm joining you from San Mateo County in Northern California. which sits on the traditional and unceded ancestral homeland of the Ohlone peoples. And, Northern California is a place where indigenous communities have lived and moved through for hundreds of generations, and they're still present in the region today. And I'm acknowledging my presence here because I think it relates to our conversation as well. In thinking about decolonization as an urgent and material project, I think it's important to think about the different ways that decolonization operates in different contexts and what it might mean there, and how conversations that we have in one context about decolonization, I think, have to be faithful to other conceptions that are just as urgent. And the reason why I'm mentioning this, over the weekend, I was at a workshop that in which Indigenous leaders participated, including from not too far away from where we are here. And one of the leaders was making the point that there are often moves that are made by refugee protection advocates, by immigrants' rights advocates, and I would count myself in this context, where we're advocating for greater protection for people who are moving, and our advocacy for those greater protections, which I see as definitely pushing back against colonial regimes that have limited mobility in racially discriminatory ways and ways that reproduce hierarchies. Sometimes that advocacy can be in tension and can reinforce the settler colonial domination of indigenous nations because the projects aren't being understood side by side. So I wanted, in my land acknowledgement, to also highlight that some of the conversations that we're having here are important, because putting advocacy that is intended, I think, to advance the emancipation of groups on the move, putting that in the framework of empire and colonialism, I think can help us think in more responsible ways about how our moves to create greater freedom from certain groups doesn't result in the subordination of other groups. And I think, to the extent that we're wondering what value a decolonial frame might have, I think it is for centering us in understanding overlapping regimes of power that have subjected different groups to different forms of subordination on the same bases. So bringing everything I said back to our conversation today, which I want to mark as well, takes out of the fixation of conversations that focus on refugee protection only in the context of places that have adopted the Refugee Convention itself. So even just the move to really say we should be taking seriously the way that refugee protection is taking place outside of the Refugee Framework Convention, I think speaks to a decolonial move in a way that Ian's Marx kind of foreshadowed, which is this, thinking beyond just where the refugee regime to think about other ways of approaching refugee protection. I want to mark that as an important contribution. But I will say that in listening to and learning from the colleagues who are about to speak, I think what I'm excited to think about is how concrete litigation that is about challenging laws that are anchored and come from and have a colonial genealogy can sharpen or deepen our understanding of what the project of decolonization is in itself. So rather than just thinking that our conversation is about seeing how litigators are decolonizing refugee law, I think what we should be thinking about is how the concrete work of litigators and others whose advocacies on behalf of refugees can actually reshape and deepen and sharpen those of us who are thinking in the frames of decolonization. It can sharpen our own understanding of exactly what it is we are and should be talking about as well. So I'll stop here, and having warned you that for me, this is about really deepening and thinking about questions rather than delivering solutions. I feel like I've really honored that in not having, offered you any conclusions, and rather what I'm trying to do is offer an invitation that I hope can be taken up in some of the dialogue we will have once we get to Q&A.
Thank you, Professor Tendai, for those framing remarks and, in fact, questions, as you rightfully pointed out. A warm welcome and thank you to all the panelists and attendees who have joined us today. My name is Zaid Hedri. I'm the Executive Director of the Refugee Solidarity Network, one of the co-organizers of this event. I want to quickly thank my colleagues and the GSLC for all the work that was put into making this event possible. As I'm sure all of you are, I'm struck by the questions and remarks that Professor Tendai so eloquently put forward. RSN brought some of that thinking to bear when conducting a joint research initiative with the Open Society Foundations that culminated in the report Undoing Precarity, which you mentioned and is linked into the in the chat. Undoing Precarity came about initially when RSN and Open Society Justice Initiative came together with Bangladeshi civil society leaders in 2018 to take stock of the country's response to Rohingya refugees fleeing the 2017 genocide in their home country of Myanmar. At that time, in addition to sharing their insights, Bangladeshi civil society requested our participation in bringing comparative regional perspective for their consideration. Given that Bangladesh is not a signatory to the 1951 convention, attention was to be paid to the experiences of other non-signatory states in South and Southeast Asia in managing refugee populations. In other words, our civil society partners were not interested in a lesson on international human rights. They themselves are no strangers to refugees or the concept of forced displacement. They sought something beyond the traditional playbook, rooted in international instruments as a, quote, panacea for forced displacement. They were looking for something more comparative and relevant for their context. And so in carrying out our comparative analysis, we came to find that colonial legacy played a significant role in creating the frameworks that were still being used to manage non-citizens across South Asia, the frameworks that enabled, or in some cases forced, the very bad practices that we observed as advocates and those monitoring human rights. The colonial traditions were not only significant in looking at the foundation of law and policy, but also in looking ahead. We were confronted with how to avoid the imposition of frameworks when putting forward considerations for the way forward. We sought to avoid a report that called for Bangladesh and the other 5 countries we looked at to ratify and accede to the 1951 convention and put in place protections in line with international standards. Certainly, we feel that this would be a positive measure, but we were then and are now conscious of Professor Tendai's framing that the international refugee rights regime is itself deficient in many respects, incomplete and inadequate as any system, not least one that was clearly shaped by colonial legacy. So the resulting report confronts a wide scope of questions and challenges and could not address every single one. But we did, as co-authors, resolve not to focus entirely on challenges and rights violations across the region. Those are well documented. Or the suggestion of a solution entirely rooted in international law. Instead, the report attempts to identify what steps have been taken within these 6 contexts that create some degree of protection for refugees, to focus on what has been made possible, often through tireless and bold efforts of civil society in each context. The report also seeks to propose some considerations for ways to improve conditions and achieve legal protection for refugees by way of reinterpreting existing domestic mechanisms and their application. We hope the report, by sharing experiences from across the region, can inspire national level actions, not only in Bangladesh, but in any national context, and perhaps through regional or sub-regional concerted actions. However such action unfolds, we as an organization are ready to play a supporting role wherever we can to indigenous efforts to improve conditions for non-citizens, and are consistently questioning the role that international legal instruments, standards, norms, and practices should play in bringing about those changes. I'm happy to wrap up here and turn to practitioners who can go into much more detail about the developments in 2 key refugee hosting contexts in South Asia that are featured in our report. I'm excited to hear from them on how colonial era laws have shaped their efforts and on their opinion for the way forward. First, I'll turn to Roshni Shankar, founder and director of MAP, working in India, and then on to Omar Jilani after that. Roshni?
Thank you, Zaid, and thank you to Professor Tendai for those excellent opening remarks. If I were to give my talk a title, it would probably be decolonizing by convenience. And that is something which we experience firsthand in the region that we operate in. And I'll explain why. So as, I mean, all of us know, South Asia, migration has been a central phenomena in South Asia. Most of the countries are born out of partition experiences, post-independence partition experiences. What that means is that most families in Pakistan, in India, in Bangladesh have very deep-rooted lived experiences of the partition. So displacement, conflict, chaos is not something which is new to us. We are deeply, deeply rooted in those experiences. It's still very, it's part of our recent history. And so what one would expect is that we have a regime, a protection regime, which is more empathetic, which is more welcoming, and which is more understanding of migration. So something which Professor Tendai says, like, we should be the experts in having a framework, a decolonized refugee protection framework. But is that really the case? So unfortunately not. So I will, I mean, the reason for that being that we adopt a paradoxical approach when we deal with migration and with asylum seekers. So on one hand, we have the countries in the region have rejected the 1951 convention, saying that it is very World War II centric, it is Eurocentric, it does not, it is ill-equipped to address protracted refugee situations. It cannot keep up with neoliberal economies, the kind of migration that we see in neoliberal economies. And most importantly, it places an unfair burden on developing countries, and it imposes sort of economic and financial burdens on the global South. So these are all valid sort of reasons for rejecting the human rights framework, the Western human rights framework, quote unquote. However, at the same time, what we've seen is that countries in the region have been very comfortable with the notions of citizenship, which are also deeply rooted in colonial traditions. The concept of citizenship sort of is deeply rooted in the concept of exclusion. And we see it playing out today. So we see it, for example, with the Rohingyas in Burma, in the constitution. They were excluded from the constitution in 1948, right after fighting colonialism. And we see it playing out in India right now. We have the National Register for Citizenship, so it's in the NRC, where we're excluding millions of people living within our borders, and which would probably lead to one of the biggest statelessness crisis in the world. So we see both these sort of factors playing out, where it's become, like I said, decolonizing by convenience. So we want to sort of reject the human rights framework, saying it's very Western, it's not rooted, and it is not it's not informed from South Asian experiences. But at the same time, we're very comfortable with concept of citizenship, border controls, immigration management, etc. So what are we left with as practitioners? What do we work with? So we have a system which both of you have mentioned. We have the Foreigners Act, something which is sort of common to India, Bangladesh, and Pakistan. I think the wordings are similar. It's a very simple piece of legislation which says, which gives the state arbitrary power and wide discretion to detain and deport anybody who's not a citizen. And how is a non-citizen defined? Anybody who's not citizen is a non-citizen. That's it. It's as simple as that. So we don't have any special categories for people who need humanitarian assistance. We can't protect people who are survivors of trafficking. So there are no special categories. And what's worse is that we don't have a parallel structure. We don't have a domestic asylum law or a refugee protection law which defines who is a refugee or what are the country's obligations towards protecting refugees. Now, it sounds very bleak, but that being said, we also need to look at the practice or the state practice when it comes to refugee protection in the region. So I will speak for India, and Umair can sort of talk about Pakistan. But in India, we've had a very strong track record when it comes to refugee protection, and it started with post-partition, it's with the Tibetans, then with the Bangladeshi refugees, and then Sri Lankans, and more recently with the Afghans and refugees coming from Myanmar. So how do we protect refugees in India? So we have an ad hoc executive system where different groups are treated differently. So we have an excellent track record when it comes to the Tibetans and the Sri Lankans. With the Tibetans, they were given rights almost, they are being given rights almost at par with citizens. They have land rights. They have, the government in exile operates out of India. They've been given housing, they've been given work rights. So a whole plethora of rights were given to the community. And it is still something which India is lauded for. close to that was the Sri Lankan experience, where they were not given access to citizenship rights, but they were given, they were able to, exercise socioeconomic rights. They were able to avail welfare schemes in India. So these are some of the best practices, at least in the Indian context. However, what has happened since then is that these policies are not consistent. They're not applied uniformly. So what it essentially means is that different groups are treated differently. So we don't have a uniform asylum process. We don't have a uniform documentation issued to refugees. So for example, the Sri Lankans have a refugee card, but the Tibetans have something called a registration permit. Somebody is given a stay visa and somebody is given a UNHCR refugee card. So it's a very complicated protection regime. And it keeps changing depending on the government of the day, and it keeps changing depending on our geopolitical interests at that point of time. And I assume this is world over, this is the experience. But when you don't have a law at all, you have a framework which is very volatile. You have a framework which practitioners cannot rely on. And more importantly, it even excludes people who previously had rights. Suddenly they don't. They find themselves that the government has changed and now they don't have the same rights or the documentation. So you can't rely on anything. There are no precedents. And so you have very, very limited tools for advocacy when you're advocating for this community. So within this context, when we as legal practitioners go to court, what are the tools that we have? So like I said, it's a very complicated regime. And what you need is to be constantly be informed about the executive policies, the sort of international relations which is at play at that point of time. And you need to know, and you need to be innovative with the existing framework that you have. So one of the biggest tools that we have is the Constitution of India. It does trump individual liberty at every point of time. We have fundamental rights which the courts have time and again said extends to everybody, not just citizens, but it also extends to non-citizens residing within India. Not all the fundamental rights, but at least the core: right to life, right to rule of law, right to due process. All of this is applicable to anybody who's residing within the territory of India. The second thing that we rely on is complementary laws, which means that you don't look at refugees from the lens of a refugee, but you look at them as a woman living within the territory of India who is vulnerable to sexual violence, or you look at a child as a child residing within the territory of India and therefore has certain rights. So for a good example of that would be the Right to Education Act. So we have a domestic law which says that every child residing within the territory of India should have access to primary education. So it doesn't matter if you're a citizen or a non-citizen or you're an illegal immigrant, it doesn't matter. So long as you're below 14 years of age, you should have access to public schools. So we use laws like this to build a protection framework for the community. So not looking at refugees as refugees, but looking at them as children or women or those with different kinds of protection needs. And the third thing that we rely on is international law. We look at laws which India has signed and ratified. So if it's not the Refugee Convention, we look at the ICCPR, we look at the ICSCR, Convention Against Torture, CRC, CEDAW, ICERD. So there are these plethora of international sort of instruments which we've signed, some of which we've ratified. So we rely on that. And most of them enshrine the principles of non-refoulement. And this is something which we are able to use in courts, sometimes successfully, but sometimes not so successfully. And lastly, we look at state practices. So like I said, we have 75 years of state practice. I think we have a rich tradition of extending asylum. And so there are a number of executive orders, there are a number of policies, rehabilitation policies. So there's just a lot of experience between different like Indian states which have extended protection to refugees. And this is something which we are able to use when we engage with the government for advocacy. Now, what is the way ahead for countries like India, which continue to like sort of shun the 1951 convention and also refuse to adopt a domestic asylum framework? So like I think Zayed mentioned, and it's also mentioned in the report, I think over the last 20 years or so, we've completely moved away from advocating for countries to sign the 1951 convention. I come from a UN background. I worked in the UN, and it's something which I'm almost conditioned in thinking that is the best model that we have. And as I work from the other side now as a practitioner within the domestic context, some of these arguments of it being Eurocentric or it being ill-equipped to handle the kind of refugee crisis that we're seeing, it does resonate with me today. And we've moved away from advocating for all countries to sign the convention. What we are advocating now is to consolidate regional experiences and make a law which is contextual, which is sort of enshrines the principles that we believe in. Concepts of asylum in the region go as far back as many centuries ago, because it finds sort of references in our religious texts. It is something which is deeply cultural to us. There are strong local customs which further refugee protection, and it's just something which is very familiar in this part of the world. And so we take these customs, we take local customs, we take certain code of conduct that have developed over a period of time, pre-colonial customs, and we use that and we build a regional framework. And that is what I think a lot of practitioners are talking about. Professor Chimney, which Ian had mentioned in his opening remarks, was in the forefront of this. And in the 90s, there were some efforts made to bring countries together in South Asia and develop a model law. And I think there was a model law which was developed with basic principles of refugee protection was stated in that. And then countries were supposed to develop a domestic asylum framework based on that. However, I think after 5 to 6 years of consultation, nothing came out of it. But that being said, I'm an eternal optimist. I feel all the countries have signed the GCR, and there is a lot of conversation still going on about regional cooperation and coordination. And I'm hopeful that with more national dialogue and sort of advocacy around this issue, maybe we will see a day where countries come together at the same table and we're able to talk about a regional framework for protecting refugees. So I think I'll stop here because I've finished my 10 minutes. I think that, yeah. Okay.
Thank you, Roshni. Thank you so much. Over to Umar Jilani to share perspectives from the Pakistani context.
Bismillah ar-Rahman ar-Rahim. I begin with the name of the Almighty, and I pray that this session may bring us closer to truth, beauty, and justice. I like the topic, decolonizing the law, because related to refugees, because I think at the core of the legal crisis in many post-colonial countries is an uncritical and unreflective adoption of colonial traditions and colonial jurisprudential paradigms. So I hope everybody can you hear me clearly, Zed? Okay. So I think it's really at the core of the issue. For the vast majority of human beings who live in the world today, and if you look at the numbers, we're talking about China, we're talking about South Asia, which is probably the largest civilizational unit in the world. We're also talking about Latin America. We're talking about these places where most human beings live, not about London and New York. The legal traditions are often quite far removed from what the people both believe in and practice. So I think it's decolonizing is such a huge challenge, but the prospects of what can be achieved for humanness through this endeavor are also equally enormous. It's a challenge that is both huge, intimidating, but also tantalizing. I want to speak about, firstly, the existing legal framework regarding refugees in Pakistan, then move on to the both the statutory and the constitutional framework, and then I want to move on to what I think is the practice. And finally, I would like to speak a little bit about my own humble contribution to this area. And yes, of course, I do want to thank everybody who is listening to us and who has arranged this gathering, and also the speakers before me, especially Roshni, because her optimistic and eternally optimistic perspective shines the light on all of us. And what else would we expect from someone whose very name is Roshni? Roshni means light, and we all need more of that, especially legal practitioners who challenge, who practice in the post-colonial world. So the existing framework. So it's the same in India as in Pakistan. The 1946 Foreigners Act, read together with the Citizenship Act of 1951. So if you read the two together, it's a binary framework, as Roshni has already pointed out. You're either a foreigner or you're a citizen. In fact, if you're not a citizen, you're a foreigner. And every foreigner is illegal except if he or she has a valid visa. And there seems to be no distinction drawn between people who entered on a valid visa, but their visa has expired, or people who entered without a visa at all. There is no mention of anything such as a refugee. People who, there's no distinction that the Foreigners Act draws between those who came to our country, out of compulsion, and those who came here happily. There's also, so if, when I look at it from my perspective as a Pakistani Muslim, as a Punjabi, I find it strange that there's no mention of, if you, the word, what are the words that we have for people who fall in that category, foreigner? One of the words is guest, right? A mehman, right? In most traditions of South Asia, and maybe other parts of the world too, there's the idea of the guest, that there is a tribe. So in every particular area, there is a number of tribes who live there, who are indigenous, and then there's other people who come there as guests. There's no mention of a guest. There's also no mention of a muhajir. So the term muhajir, if you talk about Pakistani, to any Pakistani who is not fully soaked in the Anglo-Saxon legal tradition, the word that they will use is not refugee. The word that they will use is muhajir. And muhajir is a word with deep roots in the Islamic and Indian tradition. And muhajir is somebody who has been fled. It brings memories of the Holy Prophet himself, who lived a very important period of his life as a refugee. It also brings memories of, in the Pakistani context, of millions of people who had to flee the eastern parts of India, of the subcontinent, in 1947 because of the enormous violence that, communal violence that broke out. So roughly, 25% of Pakistan's population today has some recent history of displacement. Either they came from India after the partition, or they migrated from East Punjab to West Punjab during the Canal colonies movement. So these are concepts which are not there simply in the existing statutory framework. But the part of the formal legal system which does offer some recourse to us in protecting refugee rights, in perhaps a springboard, something which can be utilized to create a refugee-friendly discourse, is the Constitution once again. In this case, the Constitution of the Islamic Republic of Pakistan. And the Pakistani Constitution, there are two parts of that Constitution, two sort of themes in that Constitution, which are quite refugee friendly. Firstly, the Pakistani Constitution is quite overtly steeped in an Islamic phraseology, and it refers repeatedly to the right of all. It refers repeatedly to the idea of creating a state which is based on the principles of Islamic law. and also on what it calls the Islamic principles of social justice. And historically, Pakistani jurists have argued, relying upon these provisions of the Constitution to expand the scope of fundamental rights. So there's dozens of cases where colonial laws have sort of been set aside or read narrowly, and rights have been read, citizens' rights have been read broadly by the courts in the belief that this is perhaps closer to the Islamic notions of justice. And the second part of the Constitution, which provides a lot of recourse for a lot of material for defending refugees, is the fundamental rights chapter. So the Pakistani Constitution has Articles 8 to Articles 28 dealing with the fundamental rights of fundamental rights, including the right of equal protection of law, the right to protection of property, protection of religious freedom, protection of human dignity, very broadly used terminologies. And interestingly, most of these fundamental rights are not limited to citizens. Most of these fundamental rights also extend to all persons presently in Pakistan, quote unquote. The term used is all people presently in Pakistan. So interestingly, we have a constitutional document which extends citizenship rights, fundamental civil liberties, not just to citizens, but also to all persons presently in Pakistan. And this quite obviously includes foreigners of all kinds, not just not just those on a visa, but possibly also those on those who are refugees presently in Pakistan. So just to sum up, so now I want to speak very briefly about, so I've spoken about the existing law, I've spoken about certain areas of the law which do provide a foundation for decolonizing the law on refugees and creating a more open, more rights protective jurisprudence. And now I want to speak about a couple of things that I've been up to recently. So most recently, I have, in fact, what brought me in luckily with Zaid Haidari is that after the takeover of the Taliban, there was around 300,000 people who fled from Afghanistan to Pakistan. Actually, before I get down to my work, I want to say a couple of words about the practice in Pakistan. So I think as in India, while the law is not particularly refugee friendly, the practice of the country and especially of the people is extremely refugee friendly. So as a citizen of Pakistan and somebody who thinks of himself as a part of the Muslim Ummah, I take a tremendous amount of pride in the fact that my country has hosted more refugees than any other country, possibly any other country in the modern world. So this country was created to host millions of refugees, and in the Afghan war we hosted a lot of people. There's a lot of Somalians, there's a lot of Palestinians, there's a lot of Chechens, mostly people from the Muslim world, now a lot of Rohingya. So my experience in Pakistan I was born in a city full of refugees, and every year I've seen more coming. And people in this country generally, there's no doubt that there's no shortage of xenophobes in the world now, but there's a whole lot of people here who do genuinely feel for refugees and who consider it an important part of their identity that we are a people who will host refugees, who will do whatever little we can. So anyways, that's the practice. South Asian practice is something stellar. And I think it's not just the Islamic tradition, it's also all the traditions of the rich religious and customary and tribal traditions of our people, which have in practice, they may seem primitive to other people, but if you look at it sociologically, these traditions have managed to create more rights for refugees than perhaps the standard modern Western liberal discourse. Anyways, now I return to the subject of what I've been doing. So most recently, there was around 300,000 Afghans who fled the Taliban takeover, after the Taliban takeover, into Pakistan. And the government a few months ago announced that it's going to deport all of them. As a part of, this is an Pakistan's negotiations with Taliban government, with the US government, as a part of their realpolitik, they made an announcement that they're going to deport everybody. And the Foreigners Act actually does allow them to do all of that. So I've been in touch with a lot of refugees who were understandably and very unfortunately very scared of this government announcement. So we filed a petition. I filed a petition on their behalf. I personally filed that petition as a petitioner in person before the National Commission of Human Rights. My petition is still pending. What I argue in my petition is that the fundamental rights incorporated in the Pakistani constitution imply that there is a right to asylum in Pakistan. And this implication also follows from a Pakistani, from our jurisprudence, which says that international customary law is applicable in Pakistan. So both because of Pakistani constitutional law and international customary law, the government is entitled, is obligated to at least consider the asylum applications and decide them before deporting anybody else. So my argument is that before any person can be deported, if he or she has made an application for asylum, that application must be decided and a speaking order be passed, explaining why their application for asylum is being rejected. This cannot be done without some adjudication, which is both impartial and independent. So that's one front. That case is still going on. There's another very important thing. Pakistan has like millions of Afghans, over the last 3 decades have come here. So I have been arguing that under Pakistani law, which recognizes the right to usufruct, birthright citizenship, most of them, a vast majority of them, are now entitled to Pakistani citizenship. So there are pathways that exist within Pakistani statutory law for refugees to become citizens. And these pathways are extremely critical. They can be extremely beneficial to this community. So I have filed a number of cases in one of the cases, the High Court, Islamabad High Court, has actually accepted in principle the interpretation of the laws that I have been arguing for, which is that every child born in Pakistan is entitled to Pakistani citizenship, and there is no exclusion in this for children born to refugees and even to illegal immigrants in Pakistan. If their children are born here, they are entitled to citizenship. There is a third idea that I have been dwelling upon, and if I may share that. So it's a litigation idea, which is that I'm going to end on what I started with, which is when I look at the Foreigners Act and I juxtapose it with my own understanding of Pakistani and Islamic law, it just doesn't fit in. Like this idea that the government is empowered to simply shunt out any human being who doesn't have a valid visa without even any appellate process, without even any kind of rights, without even looking at whether this person was trying to flee religious persecution or not, is patently contrary to our understanding of the rights of refugees under the Sharia. So I have been thinking if I should challenge the Foreigners Act in the Federal Shariat Court, which is empowered to look at the vires of these colonial era statutes and decide them and see if they are in accordance with the Sharia. So I feel that litigation of that sort could both create positive narrative, because I think these rights of the refugees, we can plead all we want for to our people about the rights of refugees under international legal conventions, but these rights will only be endorsed by the lawmakers and by the enforcers of the law, if we can somehow convince them that these rights stem from what the traditions that they believe in. And in this case, in the case of the Pakistani setup, that is definitely the Sharia. So I'm interested in exploring that subject, and on that, I would like to thank you all for listening very patiently.
Thank you, Omar. Thank you, Roshni. And of course, thank you, Professor Tendai. Three incredible interventions, exactly on perfect timing. Here we are at the juncture where we're going to be transitioning to Q&A. So thank you for your wonderful remarks and for staying quite perfectly on time. Before we proceed, I would like to encourage everyone on the line, all the attendees, if you have examples of practices or laws, colonial era laws or practices that you have worked to combat, whether through litigation or advocacy, please feel free to share those in the chat. This is meant to be, an information sharing opportunity for everyone. I think we have a lot of litigators from various contexts on the call. So sharing any information that you'd be willing to in the chat is highly encouraged. As well as submitting questions for panelists. Before we turn to any questions that are coming from attendees, I want to encourage some responses from our panelists based on what has been shared. So we have a much more thorough understanding of some of the tradition, the way that it's played out, and the challenges that have been presented in India and Pakistan. I wonder if we start with you, Professor Tendai, if you have any reflections, having brought very interesting framing remarks and questions to us at the beginning, now that we've heard from Roshni and Omar, if you have any thoughts or further questions to pose.
Thanks so much, Zaid, and definitely just call me Tendai. I'm wishing I had spoken even less at the beginning, because I think, as everybody can tell, the level of granularity that Umar and Roshni have been able to provide us, and concretely what it means to work in these frameworks, I think is really exciting. So I had one reflection and then a question. So the reflection is just, I think really both presentations highlight the challenges of overcoming or decolonizing law and refugee law that is presented by the fact that colonial technology, if we think of legal institutions and legislations coming out of the colonial areas, colonial technology, one of the challenges to overcoming the effects of that technology is the fact that that technology is very valuable to post-colonial regimes that can incorporate them to consolidate and preserve power dynamics that keep their own populations and even refugee communities alienated. So I think that is a real challenge that is highlighted in both presentations. But I guess my question for Roshni and Umar is the following. I think both of the examples that you provide are really helpful for thinking about alternative frameworks and paradigms that can anchor protective outcomes for refugees that are separate from the liberal regimes of the Refugee Convention and the ones that international refugee laws typically obsess about. And I think that point is such an urgent point. And you mentioned Sharia law, you mentioned just religious and tribal traditions that really offer concrete normative frameworks that we can be turning to. And then Roshni, you highlighted regional processes that are about building on different kinds of legacies and histories. My question then becomes, how do we think about the international? And when we're thinking about the international, I'm thinking here not as a source of solutions. We can all agree that the international is not where the solutions are necessarily coming from, but the international is a source of problems, and it's a source of problems that are exacerbating displacement, including in regions like South Asia. And here I'm thinking about climate change and climate-induced displacement, and just people moving and what we are likely to see in the future and in the present, and thinking about even displacement that isn't talked about in the language of climate and environment, but is rooted to either conflict or ways of connecting to the earth that then result in sort of displacement. When we're thinking about that picture, we can think about regional and national and even transnational approaches that are outside of the international as we know it. But it strikes me that even for people who are thinking about displacement, there has to be a framework, I think, for making demands of the international community or kind of the actors that are most responsible for the climate crisis, past and present. And I'm wondering where you see that located in your work. And I'm also curious if you think this is just not the right question to be asking, or a marginal question to be asking, and a question that itself is steeped in obsession with the international and the global, which I will gladly concede is where my mind always is. So essentially, I'm asking to Roshni and Uma, is this something to be thinking through in the context of this conversation? Or do you think that that is not quite as prominent and there isn't an urgency to have a demand of the global and the international alongside projects of really leaning into the regional and the outside of what we think of the international as a place where we think about building?
May, do you want to go first? Okay. So I think in terms of climate change based migration, I think the conversations are very, very preliminary right now. It is not part of like the mainstream national dialogue here. What we are talking about generally is developing frameworks for migration. We are going through a phase of hyper-nationalism right now. So even international law, and this has been our experience in the case that you're involved in as well, which is what we used to consider as strong precedents, customary international law, like judgments from ICJ, etc., are becoming soft law. They at best have persuasive value. It's seen as something which is scholarly and academic work, but it is not something which is something we're able to argue more and more in domestic courts. In terms of, climate change and migration, that is a conversation which, frankly, I have not seen happen in the domestic context at all. In fact, we don't even have a legal framework to discuss internal, climate change-based migration. So that is not something I can comment on. But in terms of talking about I think in terms of advocacy, our best shot right now is to restart the conversation at the local level, to talk about, our own sort of legacy, like you said, or talk about like the regional frameworks, the model law, which we already have. We have been working with local, legislators to develop private members' bill, which are being presented in Parliament. And though when we are advocating for it, we say these are our local practices, and this is India's, state practice, and this is our history. If you look at the definition of how refugees are, defined, or how persecution is defined, it is very close to what the convention's definition is. So in a way, we are just like repackaging it and marketing it as something which is, sort of an idea which was born locally. But if you look at the larger practice, it's still very rooted in our constitutional practice, which again draws from international law. So I think I'm rambling a bit, but I don't know if that answers your question, but I'll let sort of Omer jump in.
Omar, anything to share in response? I think we're back. Yep.
That's a fascinating question of whether the international is the problem or if it's the solution. And I heard that I'm also thinking about these questions. I think what I gather from Roshni's comments is that questions are also increasingly relevant in the Indian context as well. But I think, I don't think any of these traditions, I have to be candid here, when I say that we should challenge the colonial law using the resources provided by the Sharia and by the tribal traditions of our people, that does not mean that I have some ready-made solution in those things that can now provide a better protection. But I do think we have to look to, because there are some people who might be called fundamentalists who think that there are ready-made solutions out there, and now we can just bring them up and here you go, you got a better refugee law now. No, I think we have to use whatever these traditions offer and our hearts and mind and our eyes, and see what we create, what we can craft a better future for our people, refugees and non-refugees. That's a question which runs about the decolonization debate. But yes, I think there's something there, and I think these big ethical questions, yes. So I mean, as a lawyer, I've always because people think that these are questions that lawyers should not be asking. But I do ask them, and I think we could have a better world if more lawyers are asking these questions, which is that, why, if we believe that as the Declaration of Independence of the United States says that whereas all people are created equal by their creator and endowed with equal rights, with inalienable rights, that doesn't say the American people are endowed are created all equal. It means all people are created equal by their and endowed by their creator with equal rights. How does the world divided by borders figure into that? If the whole world belongs, I ask this question to my people here, that if the whole world belongs to the Almighty, and He has created it for the benefit of all the children of man, then how is it that you've created some of these borders and said, okay, this area belongs to these people and this area belongs to those people? And it so turns out that Canada and Russia ended up with getting half of the world. And the rest of us got little pieces, and Bangladesh got a very small, area. So, these big questions, and I would say the child's wonder, the questions which a child asks, that look, how is it that my house is so small and the other guy's house is so much bigger? These questions are at the core of the law. When I reduce the scope of my discourse to refugee rights, I sort of latently accept the right of these people to set up these borders and take the lion's share of the earth to themselves. I do not admit that. I do not, accept that right. I feel that if we are talking about a world where capital is free to travel, then it follows that human beings should also be equally free to travel. If I am not carrying a gun in my in my suitcase, there is absolutely no right that the US border agency has to stop me. Not to say that I have any such intentions. I'm very happy where I live and contented. But what I'm saying is that, look, this whole idea of locking up millions and hundreds of millions of people in small borders and saying this is your country, and everything else is out of bounds, except if you can get a visa. This idea, everybody talks about subjecting domestic legislation to the scrutiny of human rights concepts, but the US border control and the EU's border control laws, visa rejection laws, these are not subject. They are never tested on the touchstone of fundamental human rights. So these questions are all connected. If the Indus floodplains are becoming increasingly unlivable because of climate change that has been unleashed by the way we as mankind relate to our environment, that is not the fault of the people who live on the banks of the Indus. That is the fault of all of us. And to say that now the people who live in the villages on the plains of the Indus should alone deal with it, it's not human, and it is not fair. And it is deeply connected with the immigration and refugee laws of all of the world. So I don't have these easy solutions here, but I might sound angry, but I'm not very angry. But I do have claim to justice, not so much for myself, but for my people. and for all the people of the post-colonial worlds.
Thank you. Let me pose one follow-up, and then I know we also have some questions coming through, and I want to again encourage attendees to submit those in the Q&A. You both mentioned, Roshni and Omar, positive judgments, and we highlight a number of positive judgments in the report as well. So there are instances in which litigation efforts have yielded positive judgments by courts. Omar, you spoke to one that you were recently able to get pertaining to citizenship. So it seems that there's an issue with enforcement and recognition of positive judicial opinion in some cases. I wonder if you all can speak to what's happening there and what maybe are some solutions to achieving recognition and enforcement of positive judicial opinions.
So I think in terms of in India, we are common law jurisdictions. So judicial activism and judicial precedents play a very, very big role in refugee protection, because we don't have a law. So the only way we can sort of develop a framework is through judicial activism. And on that front, actually, I would say that the judiciary has been fairly active. We've had like a couple of landmark judgments from the Supreme Court. Again, in the 90s, I think 90s was generally very good for refugee protection in the region. We had a judgment which the National Human Rights Commission was involved in. So they actually filed a petition before the Supreme Court, something which is quite unthinkable today, asking for extension of constitutional rights to the Chakma refugees at that time in the northeast of India. And the Supreme Court had categorically said in that, which we continue to use till today, that Article 21, which is right to life, and Article 14, which is right to equality before law, both these provisions would extend to refugees and all foreigners who are living within India. So we use this principle to be able to give refugees access to the criminal justice system in India. So they have access to free legal aid, the state legal aid services, and they have, access to the entire justice system. The justice system itself is riddled with a lot of problems which even citizens face. However, they do have access on paper, and we have seen women especially, being able to claim redressal and activate some of these pathways and get protection. In terms of like deportation and detention, up until the case that I spoke about, which is in 2018, we've actually never had a negative judgment when it came to refugee protection. Every judgment that we've tracked so far, both at the lower court, at the high court, and the Supreme Court, says that there can't be a deportation, there can't be en masse deportation. It has to be on a case-by-case basis. Due process should be followed. Detention is not a rule, it should be an exception. So we have a lot of positive judgments which we've been relying on. And in fact, when we went to court in 2018 to challenge an en masse deportation order against the Rohingyas in India, I think we were very confident about a win in court, because we had such a strong precedent to rely on, and we felt we had international law on our side, and we just had to quote customary international law, say non-refoulement, and we'll get a positive order. And that is the confidence with which we went to court. And I think things started changing, because the climate that we operate in, and so many things influence how judges also respond to cases these days. And this is the first time where now actively in the last 4 or 5 years, we've seen a dilution of international law principles. We've seen state come to court and say that it doesn't matter if we've signed the convention, or who declared non-refoulement to be customary international law. So these are the kind of debates we've heard in court today, which is completely unprecedented for us. That being said, we are also seeing at the lower court levels, we're seeing in the northeast of India, for example, lower judiciaries actively trying to differentiate refugee cases from the Supreme Court matters which are currently pending, and they're differentiating the facts of the case to be able to give positive orders. So we've seen a positive order coming from the Manipur High Court, giving refugees from Myanmar access to the UNHCR office in New Delhi, directing the state to provide a safe passage to them. We've seen the local authorities in the Northeast sort of push back against central orders saying we are not going to push back refugees at the borders, and we are in fact going to provide protection. Because again, like these practices are so deeply rooted to their, cultural practices or local customs. And there's a lot of similarity and there's a lot of empathy with the communities there, because I think in the Northeast, the tribal identities are far stronger and than they would have with someone who's in mainland India, for example. And so there's been a lot of sort of soft resistance to what is going on in terms of deteriorating refugee protection, and a lot of that is happening in courts. So that is probably why I remain an optimist, because there's been a huge setback in some in terms of the big case which is currently ongoing, but there have been a lot of small wins and we hold on to them very dearly.
Thanks, colleagues. I'm going to jump in here and highlight some of the discussion that's been happening in the chat, and also challenge myself technically to see if I might invite Jane Mary Rahundwa to make an observation directly. I can click and allow you to talk, Jane Mary, see if you can unmute and just make the observation that that you wanted to make.
Sure. Can you hear me?
We can.
Oh, thank you so much for everyone who spoke. This session has been so interesting to me personally. I wanted to share some experiences from Tanzania, and probably that would be similar across some East African countries. So one example of how we are trying to decolonize refugee protection is through adoption of the OAU Convention that most of you are probably aware of. And one of the biggest changes that the OAU Convention brought was on the definition of a refugee. And Tanzania was at the forefront of drafting that, but also we adopted that in our national law. And so we have removed, we have broadened the definition to include people fleeing generalized violence. And that means they do not have to show that they're individually persecuted. And that responds to the realities on the ground that most of the refugees that we receive within the Great Lake regions are not necessarily being targeted at individual level. But so that is on the positive side. But also another example that I shared with Ian and other panelists is the example of how Tanzania treated the we call them refugees, but I know UNHCR and other international actors wouldn't regard them as refugees. But these are the people who fled or who were involved in wars of liberations who came to Tanzania. And I remember in one of the speeches that our first president, Julius Nyerere, said, it doesn't matter whether we get the international support or not, but these people, to us, they are refugees, and no one should decide who should we consider as a refugee. So that's one of the bold steps that was taken during that time. And maybe many people would remember the history that Tanzania did host many freedom fighters from mostly southern part of Africa. On the other side, personally, my observation is that we still put so much emphasis on the borders and deciding who can, like, we really forget the fact that before these borders were drawn, most of the communities were just one community, and the borders divided them, and they were living together harmoniously. They speak more or less similar languages. They share cultures and so on and so forth. Even families split between different countries. But we tend to forget this when it comes to refugee protection. So when refugees cross over, we stick to the laws, be it international or national laws, that really discriminate them. We forget that these are the same people that they cross they do business with the locals. They have families on both sides. We just forget that. We also have the East African community that has a lot of these protocols on free movement of labor, of people and all that. And the refugees we are receiving are coming from members from within member countries. But then when they're refugees and they cross borders refugees, we totally forget that. So that's an area where I feel like we're not yet there in terms of decolonizing refugee protection. So that's a few comments that I wanted to add about Tanzania. Thank you, Ian.
Thank you so much, Jane Mary. Oh, it's a pleasure. And one of the exciting things of this webinar is to be able to put these practices that we're hearing about and the expertise grounded in the particular national context and regional contexts that are highlighted by our interventions from Umar and Roshni, and also the Undoing Precarity report, into dialogue with members of the GSLC and attendees from around the world. On that note, before turning it back to our panelists, I did want to invite Ahlan Arulanantham to briefly contextualize the links that he had provided in the chat to jump to yet another region of our participants. So Ahlan, let me again challenge myself technically to enable you to speak. One moment. All right, I believe you should be able to intervene.
Can you hear me, Ian?
Yes, thank you.
Great. Yeah, thank you very much. First, I should say this has been an extremely interesting and thought-provoking discussion. I've learned so much from listening to it. And I also have maybe I'll start with, I have a brief question or something which I've been pondering as I've been listening to this, which is, I am very sympathetic to, and I love the concept of decolonizing refugee protection law by focusing on domestic frameworks in other countries, and particularly in South Asia. And at the same time, I also know that here in the US, there is a fairly long sort of counter tradition of trying to export refugee protection by encouraging countries closer to the quote unquote sending countries to take on their fair share. And sometimes this has been called burden sharing explicitly. I am interested in thinking about how the focus on improving regional protection frameworks in South Asia, say, for example, could undermine efforts to improve refugee protection in the United States. And I say this in part because I did some work on the protection of Sri Lankan Tamil refugees in South India, and have done a lot of work on human rights in Sri Lanka over time. We have often looked to India as a model, thinking how much better it is at protecting Tamil refugees, Sri Lankan Tamil refugees, than the US is. And I remember talking to people and saying, you know, very rarely do people get jailed while seeking asylum in India, at least from the Sri Lankan Tamil population, whereas here it's the norm. But I also remember being in certain kinds of conversations where people would turn that around and say, like, yeah, see, isn't it so much better? People should just seek protection there rather than coming here. And I know that's an argument that has been made in the context of Australia as well, and it's protection of refugees. And I wonder about, I mean, it seems like it's one thing for people, you know, like Roshni and Umar, who are, you know, practicing in India and Pakistan to advocate for stronger refugee protection in those countries. It seems very, very different for someone in the US to do it when it has this kind of valence to burden sharing. And then, I don't know, like people who are kind of halfway, you know, sort of have a foot in both worlds, it's tricky. So I don't know, I've been pondering that. I've been listening to this. But anyway, to answer your question, I am part of a group of people that have done a lot of work here in the US to challenge the criminalization of unlawful entry and also unlawful re-entry after deportation. These are criminal laws in the US. They're actually the most prosecuted crimes in federal criminal law in the United States. They were also the part of the real engines of what drove family separation in the United States. People coming here seeking asylum who would cross in the border, usually because they would not be admitted in the port of entry. would then be prosecuted for having illegally crossed the border, and they would separate the parents from the children in the course of that prosecution. And it turns out that those laws originate from 1929 in a period when the immigration laws in the United States were very explicitly based on eugenics and theories of white supremacy. There's actually a lot of immigration laws in the United States, if you uncover the history, that have their origin point during that time period. And although the domestic constitutional law here is very thin, one thing it does permit is laws to be challenged if they were motivated in their origin by racism. And so we have brought constitutional challenges to these laws, saying that they are unconstitutional because they're very clearly motivated by racism in their origin. And we actually won that in one court in Nevada. The government then appealed that, and now there's cases challenging this issue on appeal all over the country. I would be surprised if it ultimately wins in court and it all gets struck down, but I do think it has advanced the conversation about racism and immigration and their sort of connection, historical connection, and its ongoing sort of valences in the present day here in the US, and particularly on the question of so-called illegal migration or unauthorized migration. And that's what the links that I put in the chat are about.
Thank you, Ahlan.
So I think we're running out of time, unfortunately, because we have a few more questions that are being posed. So I think we're going to have to go back to speakers for any final remarks. And in doing so, please feel free to address one of the remaining questions, which is a really great one. Basically asking how we can promote good decisions across contexts. I mean, there seems to be, of course, states like to share bad practices, and there tends to be a race to the bottom. How do we reverse that? How can we promote the sharing of positive precedents? You can take 90 seconds or so, each of you. It would be great to hear from you one final time.
So maybe I'll go really quickly. Ahlan, thanks so much for that intervention. And for anyone who hasn't seen the report that Ahlan is referring to, could not recommend it more. But I think that question about how we reconcile moves by global North countries to use basically regional containment to trap refugees in certain regions by saying, let's strengthen the regimes there so people don't move. How we reconcile that with really urgent efforts for regions themselves to strengthen their own protection regimes for their own needs, I think is a really important question. And I think it helps us come back to, again, the possible value and maybe limits of using the frame of decolonization. I think, again, if we can situate policy, transnational policy dynamics like the Biden administration basically, having its root causes strategy that's focusing on keeping people in Central America. If we can test those kinds of initiatives according to kind of a backdrop that thinks about whether those initiatives line up with the kind of initiatives that Uma and Roshni have been describing, I think it takes us further, because it seems to me we're talking about different things. If the regional project is about thinking about, an anti-colonial and indigenous and other perspectives for how you strengthen protection, and if the other approach is about redoubling forms of kind of containment that have been embedded in borders already, we can see that these are really different projects. But anyway, all to say, this has been a really illuminating conversation, and a plea to the organizers to consider making this a series of sorts, because I think we all want to be having these kinds of conversations, and there's very few platforms for bringing together practitioners in different regions and people who are thinking in different regions to speak concretely about these. So thank you so much for the privilege of including me in the conversation.
Roshni, go ahead.
So I think in our context, what we see as the way ahead for us is to look at legal interventions in a more holistic way, not just look at, strategize better. I think one of the things we've learned is sort of look at strategic litigation more from lower courts so that you have multiple forums to bring up this issue, just increase the volume of strategic litigation on refugee rights, so that you develop domestic frameworks and laws, and you're not relying on any kind of conventions or framework which are perceived to be Western. And the only way we can do that is to create more precedents, to create more, to get the judiciary more active. At the same time, there is a lot of conversation happening about the Foreigners Act internally. There have been proposals to amend it to include a separate provision which defines refugees. There is a lot of movement also happening at the state government levels, where something which was mentioned earlier, like in Tamil Nadu, they have a very strong practice of protecting refugees, Sri Lankan Tamil refugees, and there is a lot of state policies and practices that have been documented. And there is work happening in terms of trying to codify this, introducing them in parliament, and also at the same time having conversations at the regional level around GCR. I don't know whether a regional framework is something which is practical given how things are right now. But like I said, I remain hopeful. And meanwhile, we as legal practitioners just look at every forum that we have to build local laws and advocate for the community.
So I just want to thank everybody for what has been spoken today. A lot of what has been spoken here has left me thinking. I learned a lot of new things. And I think the way forward is just to keep doing what we're doing and do it better. And also, I think just, the tremendous goodness and the energy that everybody has brought to this seminar, I believe very strongly that there are so many human beings in so many parts of the world who really want to do something good about the issue of refugees, and for people who are in trouble. There's something good that will come out. The most important thing is to believe in our own ability to do something good and to do something good together. So I think that's the most important thing. Just keep going.
Perfect way to conclude. A positive note. Tendai, your suggestion is very well noted by GSLC and RSN. It's great to hear that everyone found the discussion meaningful and constructive. I want to thank everyone once again for joining. We're obviously a little bit over the time. As was noted in the chat, video will be made available, so please do share it. And a very warm thank you to everyone again. Tendai Achume from UCLA Law, Umar Jilani, Roshni Shankar, everyone at GSLC and RSN, thank you all very much.
Thanks, everyone.
Thanks.
Thank you.